For those of you participating in this webinar, the CLE code for this session is privacy. Please be sure to record this in the appropriate box on the remote attendance affirmation form that was provided.
Good afternoon, everyone. My name is John Lewis. I am the founder and CEO of a software company called Intelligis. We have a niche debt collection platform called MasterQueue that services a number of the large financial institutions in the United States as well as their third-party vendors. And joining me today are Dominique Perkins-Leipzig and Mary Ross and Lisa Contreras. And I'd like to have each of them take a second and introduce themselves, starting with Dominique.
Hi, thank you so much, John. Yes, as John mentioned, my name is Dominique Shelton Leipzig. I am the global co-chair of Perkins-Coie's Ad Tech Privacy and Data Management Group. And my practice involves just helping clients navigate the ever-evolving sort of labyrinth of privacy and data security laws that are happening around the globe. Been particularly focused on the CCPA, or the California Consumer Privacy Act, and financial institutions that we're going to talk about. I'm based here in Los Angeles and was born and raised here, so this is a particularly exciting time for privacy in California. Mary?
Hi, John. Thanks so much for including me on this webinar. I'm Mary Stone Ross. I was a co-author of the initiative that became the California Consumer Privacy Act. It's been quite a journey, and I joke I actually started on the opposite side of privacy. So my background, I worked at Los Alamos National Laboratory when September 11th happened, and I was inspired to try to stop another terrorist attack from happening through the use of information. So I went to work at the CIA, and then later I became counsel on the House Intelligence Committee. So I think I've really seen the power of information to do good. But then as I started working on this initiative and saw how much personal information businesses were collecting, and yet there weren't any set of standards or regulations in place to make sure that there weren't negative uses of that information, I realized that we needed something in California to give consumers more transparency over what information was being collected. So now that the initiative was pulled off the ballot and we ended up passing the CCPA through Sacramento, I started my own consulting business to help businesses navigate what is going on with the CCPA and other privacy regulations, as well as just help policymakers as they think about whether there should be a federal privacy law.
And that business, Mary, is MSR Strategies, correct?
That's correct, yes.
Great. Okay, and Lisa?
Yes, hi, good morning. My name is Lisa Contreras. I oversee privacy and compliance at Yamaha Motor Finance Corporation here in Cypress, California. I am a native of California, so CCPA is very interesting to me from that perspective as well. My career started in the judiciary system, where I worked for a judge at the Los Angeles Superior Court, basically managing the courtroom from A to Z as a court services representative for the judge. In addition to that, I evolved and went into the financial services industry, starting in mortgage banking. And then the financial crisis hit, so then I moved on to auto captives, have evolved from there, and now I'm at Yamaha Motor Finance Corporation here.
Great, thank you so much. So I'm going to start with Mary, since your hand was on the pen, so to speak, in regards to the crafting of this law. How in the world, Mary, did you get to this point? I mean, take us back to, how did CCPA and data privacy even come about, and how did you specifically get involved?
Sure. So, the story, and this is the story that I have heard too, is that Alistair McTaggart, who was the real estate agent that funded the initiative and came up with the idea to do something about privacy using the initiative process in California. He was at a cocktail party with a Google engineer who had a little bit too much to drink. And when Alistair asked him, so all this privacy stuff, should I really be worried about it? The Google engineer looked at him and said, oh, if you only knew how much we were collecting about you, you wouldn't be able to sleep at night. So he had this idea, and then around the same time, I had moved out to California, actually for my husband's job. So I was exploring some different opportunities, and it was kind of perfect. My background is policy, and that's where my love is. And so Alistair hired me to kind of figure out what should be in a good privacy law, and just really, it was my baby a little bit. Just go from there. It was a blank slate. And so, like I think because of my background, I approached it from, is there even a problem here? How much information are these businesses collecting? And even though I say that there's a pre-Cambridge Analytica and post-Cambridge Analytica world in terms of just the general understanding of how much information businesses are collecting, but even in this pre-Cambridge Analytica world, there was quite a bit of information out there about the extent of data collection. And it was a lot. And I was concerned that there really wasn't any way that I, as an individual consumer, could find out what was being collected on me and my device. And so the CCPA, I think it always did start as a Freedom of Information Act, but for private businesses. So I, as an individual, could go to a business and say, what do you know about me? And they would have to, in plain English, not in a privacy policy that's not written to inform a consumer, but actually say in plain English, what are they collecting about me?
So when you all first started looking at, putting something together, there were options, right? You could either go do a ballot initiative or do a law, correct?
Well, I mean, I think at that time, because remember, this was pre-Cambridge Analytica. And so there wasn't very much interest in Sacramento to do a law. There were lawmakers that Ed Chow, who was one of the co-authors of the legislative version of the CCPA, had put forward different versions of privacy legislation, but there really wasn't the push to do something in Sacramento. I think all of this changed, well, one, because we did file this ballot initiative and we collected the required number of signatures, and the initiative was very scary because it did have a broad private right of action for any violations of the CCPA, which that has since been eliminated in the legislative version, although there is a private right of action for data breaches. So I really do think that what changed the conversation was Cambridge Analytica, because privacy polls really high. Even before Cambridge Analytica, it was our internal polling that we were doing was off the charts. And then after Cambridge Analytica happened, we tested and we threw every single opposition messaging that we could think of against the initiative. And it still polled much higher than we needed in order to pass it in the polls. And so I know that the opposition campaign that was led by the Chamber of Commerce was doing their own internal polling. And I think that they were worried. And so in California, the way the initiative process works is that if a law is passed through the ballot initiative, the only way to change it is through another initiative. So that makes it the ultimate hammer, because it takes the members in Sacramento's ability to change it away. And so I think there is a lot of pressure on these legislators to do something. And I think that's why you saw this frantic last minute scramble, although truthfully, the conversation did start in about April of 2017. April of 2018. And then there was this agreement to do a version of the CCPA, but importantly, I think from the point of view of industry, it gave them another chance to go back and try to soften some of the definitions and some of the provisions that were originally in this ballot initiative.
And I would assume by now you've seen the Netflix documentary, The Great Hack.
No, I haven't actually.
You live it.
I don't watch that much TV.
You've lived it, so you don't have to, right? But I think for anybody questioning, and it's difficult, right? The financial institutions have been through so much. When the CFPB was formed, we had just launched MasterQueue, and when they launched the CFPB, I know that changed our roadmap as a software company to change every financial institution's roadmap. And I believe this is another roadmap changer, game changer. And if you're questioning, why are they making me do this? All you have to do is watch that film. And when you see how your personal information is out there, even in debt collections and for financial institutions, use of data is maybe a little different than somebody, has a device in your house and they're listening to if you're snoring and they're selling that to a company that sells sleep apnea products or whatever it is, right? All the rules are off of what they could do. So I think that it's really interesting that we've come to this point, and I think for all of us personally, it's great. We need to be protective of our own data. Data's the new oil, and you have to be very careful because it's your data.
Or your children's data.
Even more so, right? We're already kind of out there, but now we have the opportunity to kind of think about how we raise our children and how we protect them because the data has been so easily accessible, correct?
Well, and I think where the conversation has changed is when I started working on the initiative, you would hear often people would say, I have nothing to hide, or if I don't want it out there, I just won't post it. And I think that Cambridge Analytica certainly showed us. And then now that there's been quite a bit of reporting in the mainstream media, we've seen that you can't get away from it, right? Like these are apps or even physical stores that are collecting very detailed pieces of information about us, our heart rate, our biometric information, our physical location, including when we're walking around stores, and our face print. And now that combined with artificial intelligence, we can't hide, but it would be good to know what's happening. So yes, I think that it's everybody is recognizing the fact that it's time for regulation.
So give us a quick overview of who this law applies to, if you don't mind.
Sure. So the nexus is the California consumer. So it applies to any business of a certain size or who collects a certain number of records of personal information that collects the information of Californians. So what's important to note is that it doesn't matter where the business is located, whether it is in California or if it's in another state or even another country. If that business is collecting the personal information of Californians, then they will be covered under the CCPA.
Okay. And the type of data that's covered, can you talk about that a little bit?
Sure. So it covers personal information. And so that is a much broader definition in the CCPA than what a lot of companies, I think about as personal information. So personal information also includes things like device ID or IP address. And the reason for that is I think we've moved past the era where it's just our name and our social security number and maybe our email address that we consider personal information. My iPhone travels everywhere with me. And so even though it doesn't have a name or my name associated with it, it's me.
Right. So your GPS location, all your basic your name, your address, your phone number, all of that, you really need to understand what type of that data it is that you have as a financial institution. Where did you get it? What was your business purpose? What was your permissible purpose to get it? Who did you share it with? And that all needs to be in a system that you can easily track it so that you have the answers if someone wants to ask you the questions of what data do you have on me?
Absolutely, because remember, the first provision of the CCPA is this right to know. So when the law goes into effect in January, any Californian will be able to request twice a year and free of charge, what do you know about me? And so the business will have to say what categories they've collected, and those categories are enumerated in the CCPA. But then a consumer also has the right to find out the actual pieces of personal information. So for any businesses, I think step one is figuring out what pieces of personal information have you collected about Californians.
Yep. And, as we're focused on financial institutions for the call, can you explain the Gramm-Leach-Bliley exemption that was added to the bill?
Sure. So it is a complete exception to the CCPA. So I'm just going to read it as it's written now. It says the title shall not apply to personal information collected, processed, sold, or disclosed pursuant to the federal Gramm-Leach-Bliley Act. And also, just of note too, it's also information that's collected by the California Financial Information Privacy Act. And so there, I think the idea is that those are industries that are already regulated. And so it's not necessary to include that information.
So I'm going to shift gears for a second to Dominique, because I think that's probably the hottest button topic that I hear from our lenders coming to us is, can you talk about the way that we track data, and can you talk about how we can capture the data? And then there's GLBA data, and then there's non-GLBA data. So Dominique, what's your kind of take on what is the exemption? Does it really cover? And I assume have spoken to some large financial institution already about their take without naming names. Can you kind of give us an idea of, what's their impression of it as well?
Yes, absolutely. So this is actually going to be the subject of a book project that I'm doing with the International Association of Privacy Professionals. And the book is coming out on the 19th. It's called Implementing the CCPA, a Global Guide for Business. But there are quite a few things that fall outside of the GLBA exemption, as as Mary was alluding to. So first, just to tell you some of the differences, aggregate data is defined differently in the GLBA than it is in the CCPA. And that means that there's data that is considered aggregate under the GLBA, but would not be considered aggregate under the CCPA. Consumers are defined differently in the GLBA versus the CCPA. So, if you are a California resident and you haven't attempted or obtained a financial product or service from a financial institution, you will not be covered by the GLBA technically, because that only covers consumers and then customers. Also, consumers who don't qualify as customers under the GLBA definition will be covered by the CCPA. And so those mean under the GLBA, consumers are not trustees for a trust or the beneficiary for a trust. So are participants in an employee benefit plan. Those will not be consumers under the GLBA, so they will not be covered by the GLBA exemption for CCPA. There are a lot of, cookie data, behavioral data and cookie data is not expressly included in the definition of personally identifiable financial information under GLBA. But again, as Mary pointed out, it is right within the CCPA. So there's so many, the book, Appendix 3A has like a whole chart of all the things that, potentially fall outside of the GLBA exemption. And so for that reason, Mary and I were at an IAPP event recently where there were speakers from, some major financial institutions, SunTrust, Wells Fargo, indicating that they are not going to be relying on their GLBA exemption because there's so many, holes in it potentially that could expose a company.
I mean, that's what we found. We ended up going and talking to the data providers specifically, and we integrate with all the major data providers in the country. So we sat down and talked to a number of them, and the challenge was in debt collection data. So you're trying to reach someone, they have a responsibility to communicate with the financial institution, but if you can't reach them, you can't help them. And all of a sudden they go 2, 3, 4 payments past due. So the idea is, how can we reach these people? So they use consumer data to try to reach them. How can I call the landlord of the house the person lives at? Or how can I call someone else who lives in the house? And when we had a panel that we did very similar to this, Mary and I were on at the Auto Intel Summit in July in Raleigh. Becky Keene, who's probably one of the foremost authorities on regulatory rules and data privacy for Hudson Cook, a big debt collection firm back east, she said it's all about the data. you have to first understand exactly what the data is, and then you can determine your exemption. But the challenge of trying to, you run a comprehensive report on someone, and you have hundreds of pieces of data on hundreds of people, and half of it's GLB qualified and half of it's not. So you almost have to just throw that out and say, I need to track everything.
Yeah, and really, think about a culture of compliance, like you said. So the same thing, there's a bill that we're waiting to see if the governor signs, which is AB 1355, that relates to FCRA related activity, but
Right.
It will cover more, because right now the FCRA exemption is just limited to things that are covered by FCRA once again. But if you're not making a decision about credit worthiness or some kind of decision based on the FCRA related
Yeah.
credit information, then that will not be covered by FCRA. AB 1355 tries to expand that. So any kind of activity that a financial institution or other institution might, credit reporting agency might get involved in to just deal with generally, credit standing and other things that may not go to a final decision about whether to issue credit, that would be, general reputation and so forth would be covered by AB 1355. So we'll see. I just saw it made it in concurrence in the Assembly last week, and so we're just waiting to see if the governor will sign it by October 13th. Mary, have you heard anything on that front, just out of curiosity?
I haven't, but my gut says that it was, there's been so many battles in both the Assembly and the Senate in Sacramento that I do think that Governor Newsom will end up signing the amendments that passed through these houses last week.
So Dominique, how did you get so knee deep in this?
Well, it's interesting. I'm looking back at, my very first.
You didn't go to college to be a data privacy attorney.
I didn't go to college to be a data privacy attorney. I was an international relations and French civilization major, but global issues are what sort of took me to Georgetown, where I went to law school.
Okay.
And in 1990, I took a seminar with Professor Anita Allen, who is now at UPenn, and it was called Privacy in American Law. And of course, this is before, social media and a lot of other things. But back then, I wrote my paper on the public disclosure of the private lives of politicians. And this is right when Representative Frank had been outed for his personal life and so forth. And, my thought there was that there should be sort of looking at the cases and the penumbra of the Constitution, some kind of zone of privacy that's afforded to our public officials. So that was way back then. And then, back in 1998, I started working for a firm that did a lot of work for, back then it was called Yahoo. And so we were involved in some of the initial litigation as it related to privacy. And then it just continued from there, for, I would say, the past 21 years or so, just with the privacy and digital focus. So it's really interesting to see the arc and how things have evolved and changed and how much they stay the same, really the same principles of FIPS and, notice, transparency, visibility, data security. These are concepts that have been around for a super long time in the U.S. and also abroad.
So it's really a passion for you, correct? And this has become a vehicle for that passion because it's very challenging.
Yes.
I mean, it's unbelievably challenging for those of us that are in the weeds, whether it's software, whether it's, financial institutions, what have you. And, if you take a high level look at what a financial institution needs to know about CCPA and potentially other state and federal data privacy laws that may come at them soon, what does that look like?
I think that, I call it top line compliance, but I was literally just on a panel last week in Seattle with a client, and I just think there's just a tsunami of, privacy and data security regulations across the globe. I think I read in March, Uganda became like the 133rd country to have a data protection law. They all have certain features that I think lend themselves to sort of the 6 steps of compliance that were first published on the French Data Protection Authority's website, the CNIL, for GDPR compliance. And I think they work very well for CCPA, very well for FTC, very well for the SEC. And that is, these 6 steps. Phase one, or first step, have somebody or some people in charge of leading the privacy and data security function. Whether that's a task force, I like the idea of a task force bringing different stakeholders, legal, InfoSec, HR, communications, and C-suite preferably, to just understanding data. Second step is to inventory the data like you talked about, John. And so tools like yours that will allow companies to be able to know specifically what data they have, potentially financial institutions in particular. There's a lot of tools out there that are disaggregated and everywhere, but having a tool like yours that will allow them to quickly see what personal information they are collecting and in what jurisdiction, so that you can know what your compliance obligations are, very important. So second step, inventory.
And you can't claim an exemption if you don't know what you have.
Exactly.
And if you're manually gathering data and copying, pasting it into unstructured note fields, it's kind of the wild west of gathering data, which was great when there was, we used to have to do it through phone books and microfiche and drive down to the courthouse, and then all of a sudden you can push a button and get this massive amount of information on people.
Yes.
And what's interesting is we built a platform to track all that, but not for data privacy and not even for regulatory. We just tracked it because we wanted to make the banks more efficient in how they use data, because I was a skip tracer from way back when, and I knew what I did in gathering data, and it was a lot of intuition, and I felt if I could do something differently, it would be great. And then as a byproduct of that, the regulatory boards came, the CFPB, and then it's like, oh, we can actually, because we're tracking the data, we can actually say, don't call this person during this time, or only call this person so many times. And then now all of a sudden it's, it also applies to data privacy too.
Absolutely. I mean, this phase two, this inventory, is the bedrock of not only digital transformation, but also digital compliance. So when you're looking at things like AI and predictive technologies that Mary alluded to, those are all based on case models and a lot of data to feed those models so that you can actually teach the algorithm. Similar, and that involves mapping. You need to know what data is relevant to, to really get the result you want and to be as helpful as you can with your products. On the flip side, if you're doing data security, whether it's NIST, ISO, the CIS critical security controls, and then on the privacy side, GDPR or CCPA or any of the other, myriad other privacy laws, you do need to know what data you have, just like your point. So to the degree companies can use technology to be able to leapfrog and get a good understanding of what they have, that's just like the bedrock, second step. The third step is a gap assessment, where you are assessing your actual, collection activities vis-a-vis legal requirements. And as I mentioned, we've taken a very granular look at all of these laws, not just CCPA, but all of them. And there's a tremendous amount of overlap. Some areas where there's distinctions, where you might be required to have a data protection officer in place, like in Singapore, and others that's not required. In other words, you can tweak things, but you need to know what jurisdictions you're in that matter to you, and what the legal gaps are between your practices. And then an impact assessment is step 4 for really high risk processing.
Yes.
Financial, medical, children, location data tend to, around the globe, be considered high risk processing.
Yes.
And so for those, you want to have special impact embedded in, whether you have vendors or otherwise, to just really figure out how to mitigate those risks. And then step 5 is mitigation of the risk that you've identified in steps 3 and 4 through vendor management, that's contractual language or shifting liability, insurance, training, and then also your external policies, what you're telling consumers if you're a B2C, and then your internal governance policies. And then step 6 is just keeping an auditable record, so you have a handle on what your practices are. So if you get involved in M&A, acquire a new business or a new function, you can tweak to accommodate those new uses without, and certainly revisit it on an annual basis and benchmark yourself. So that's really, I'm oversimplifying tremendously, but this is after stacks of comparing and charts, myriad footnotes. It really kind of comes down to those 6 steps.
And that's what you're doing, right? Is you're guiding these large corporations on how to, you're not going to do all the work for them. They have to do the work, but you can help advise them on the direction they want to go, because you've already done it. Each time you do it, you get a little smarter, and you also understand the challenges they have, because now you're into, oh my God, we have data in 25 different systems or 100 systems, or
Exactly.
so you start to see these, and then each time you go to the next one, you're able to offer advice.
Exactly. We call upon, technical experts such as yourself, John, and, Mary with her deep knowledge and just being involved in like developing CCPA,
Sure.
it's invaluable. And the knowledge, and I mean, she and I have been on panels together. I just will say this, it takes a real group effort from, the technical side, the legal side, the regulatory side, to try to help companies be in a position, financial institutions, to be in a position where privacy is their differentiator. It's not their, Damocles sword. They're actually, able to stake themselves out as privacy champions. And I think that, to Mary's point, I mean, that's really what customers are going to be looking for.
I mean, I would think this is almost an opportunity to really take a lead and be positive about, hey, all of our employees, all of our people in the company, we protect their data, and we're going to protect our consumers' data, and we're going to be out front telling everyone, this is how we're doing it, this is what we're doing.
Yep. And I think, Mary's point, she talked about the popularity. There was a report that was done by ACLU, and it was mentioned in April. Kevin Baker, one of the attorneys over at ACLU, mentioned there was a 94% approval rating for the CCPA. And I'll send you guys the link to the study. And I think, in light of that,
everybody wants it.
I think you just
Who do you think are the 6 that don't want it? The people that have to do all the work to make it happen, right?
But yeah, so I think exactly. I think that when something is tremendously popular, and efforts will be made to make it well known to consumers, just like what's happened in the EU, it's just really important for companies to kind of like get on board with the mood in California, which is very different. And Mary, I don't know, I'd be interested in your point of view. Being up in Sacramento, I was, even being in LA, when I went up in Sacramento to testify on SB 561, which was the private right of action bill, I was really shocked at the palpable level of distrust that has been built up against companies and their responsibility. And it's interesting because I work so closely with companies that are trying so hard every day.
Sure.
But that message is not up in Sacramento. So I think people need to understand that we're kind of starting with a deficit in terms of how companies are perceived in the legislature. And I don't know, Mary, if you had the similar view, but that's something that shocked me when I went up.
I think that the pendulum has swung the other way. So I think that there is a lot of distrust, but I think that part of it is from, it's certainly not every company, and I think that's actually where one of the biggest wins is going to be, is that there's a lot of companies that are trying so hard to comply, and they're really thinking about, okay, do I need this information or not? But it'll be interesting to see that once the CCPA goes into effect, does it actually engender more trust into these businesses, because consumers will have a better understanding of how their information is being collected and used. And I think just the other points that I would make, one, privacy certainly is good for business, and that companies that are not selling personal information, they can use that as a marketing tool and flat out and say, we do not sell your personal information. And because we have this law now to back it up, people will believe it.
Sure.
And so
okay.
I think that and I think the second point that I wanted to make was that the CCPA does not cover the collection of information, including in the initiative version of it. And that was a pretty thoughtful decision that we made on the part of the drafters to say, okay, business, if you're collecting my personal information, if I'm doing business with you or I'm using your service, that is okay. You still have to tell me what you're collecting, but we're not going to place restrictions on what you collect and how you collect it. The only thing the CCPA does cover is the disclosure of what you're collecting and who you are either selling or sharing it with, and then, of course, the opt-out and the deletion provision.
Good. So before we get to Lisa, because she's the recipient of having to do all this stuff, so it'll be interesting to hear her take. I know that you guys have been following multiple bills that have been proposed up through the last session on September 13th, and I know, Mary, you were back in DC last week. Can you explain to people kind of how this is still somewhat, I mean, it seems like the law is in place now in California, but there's another session next year. Changes can continue to happen. You have all these other states that are now looking at, potential laws, and at the same time, where are we at on a federal law so that everybody doesn't have to try to
Sure. So let me, that was a lot in one. So let me try to unpack that a little bit. So as I mentioned earlier, the CCPA, when it was passed through Sacramento rather than through the initiative process, gave other players the opportunity to amend the legislation. And so what we've seen in the past year is a flurry of bills. There was always going to be one cleanup measure because there were quite a few drafting errors that were made in the legislative version of the CCPA. But we did see many, many amendments introduced. I was tracking 25 different bills. Though most of them, I think, would have softened some of the pieces of the CCPA. A couple of them, Dominique mentioned SB 561, which would have reinstated a broader private right of action. So a couple of them would have made the protections stronger for consumers. And then some are in the category of what I call neutral. Now, last Friday, September 13th, was the last day for votes in Sacramento. The governor now has another month to either sign those bills or to veto them. But as I mentioned earlier, I do think that he will sign the amendments that went through. And the ones that I think are going to be more significant are, well, first of all, I just wanted to say that the right to know, this Freedom of Information Act for private companies, is still very strong. So on January 1st, 2020, your consumers will be able to say, what have you collected about me? What have you shared for a business purpose? And what have you sold about me? And you will have to respond both in the general categories of information that you've collected and shared, as well as a consumer will have the right to find out the specific pieces of information. So, John, just as we were talking about earlier, it really is important to get a handle right now on what information you have collected about Californians.
I think what's really interesting about that for the financial institutions is a lot of times when you're gathering data, you're not just gathering data on your consumer. Along with that data comes data on a number of other people. And if you look those people up in your system, they're not customers of yours, but you have their data. And if the consumer is going out to data providers where they got the data from and asking, what do you have and who'd you share it with? Those financial institutions are going to be named as who it was shared with, but they're not going to have an easy way to find the data because it was copied and pasted and put into a note somewhere that's unsearchable through the legacy software systems these guys are using to service their loans and debt collection.
Sure, absolutely. So just a few other changes. There was a non-discrimination provision that was kind of messed up in the legislative compromise. So that's been clarified to say that the non-discrimination language is still in the law that says a business shall not discriminate against a Californian for exercising any of their rights under the CCPA. However, that has been qualified to say that a business will be able to charge more or offer different access if a consumer chooses to opt out or delete their personal information based on the value of that personal information to the business. So I think that's something that, I'll be watching pretty carefully to see how it plays out in practice in January. And then just employee information is completely exempted now from the CCPA. And there's been a few other changes. I won't go into them in super detail now, but there's an IAPP podcast that you guys can listen to for more detailed information.
Well, the one thing on the employee, though, Mary, it's like just exempted except for 100, right? Like the specific categories and specific pieces the employees can still ask for after if AB 25 is signed, which we assume it will, for a year, and then it sunsets out.
That's correct. So the way that it's written right now, it is AB 25, and employee information is exempted from this right to know, right to opt out, no matter where that information was collected. So even if it was collected by your employer during the workday or after work, which is happening, that as written is exempted from the CCPA. However, that bill was passed with a sunset provision. So that will sunset after a year in 2021. And I expect there to be a pretty big battle in Sacramento next year, which kind of segues into, is it over yet? No, it's a 2-year legislative session. So a lot of these amendments that were moved to the inactive file or didn't make it out of certain committees can still come back to life. I think that the difference is the CCPA will be in effect. And so I think there will be a lot of Californians exercising their rights, and it will be very hard for lawmakers to take those rights away. Where I expect some of the battles to be are around some of the definitions. So the definition of personal information, de-identified, and sale, which are critical to the implementation of the CCPA.
Yeah, and just to clarify, just because we've gone over this a little bit with our clients, Mary, the AB 25 is a 1-year exemption for employee data for all of the CCPA except for the requirement to notify employees of the categories of data collected by an employer. So that is still in AB 25. Yeah.
Correct.
True. Yeah.
Thank you for that clarification.
So let's turn it to Lisa. And, Lisa, as a privacy professional, what may be critical and key to an organization preparing for CCPA compliance?
Well, I would say that having a very clear understanding of what is expected under CCPA would be a very critical piece of information, breaking it down piece by piece. And also, there should be a consensus and agreement between the privacy professionals within the organization and key stakeholders in order to move forward with the strategy on how to approach the CCPA compliance project. As Dominique and Mary had mentioned, the data mapping is critical. That's an initiative that I believe should get started as soon as possible for any organization. Creating a strategic vision which can illustrate and document how the organization can achieve a comprehensive compliance with CCPA, perhaps a roadmap, if you will. And I like the steps that Dominique mentioned. I broke them down a little bit, probably more broader than that. I typically say strategy, then phase 2, design and build, and then phase 3, operationalize. But I think you can do those all pretty much simultaneously, particularly with design and build. You don't want to wait to operationalize too far down the road. Operationalizing, I think, is probably the largest challenge. So I think every organization will do it differently. And obviously, communication is key. The organization's privacy function or anyone leading the effort can make great strides, I believe, by ensuring that the key stakeholders and executives are aware of the size and scope of the CCPA project. For sure, impacted departments will appreciate the awareness of CCPA, and executives and the individuals with budgets will appreciate knowing how it will affect the business and their budgets overall.
Sure.
I hope that helps in some way.
Yeah, I think so. And, what are some areas of CCPA compliance that organizations may be overlooking or may want to include in their project plans?
Well, that's a great question. I do believe that from my discussions with various organizations in the industry, a lot of companies are really focused on the launch, being prepared to be able to launch CCPA. But then there's also what I call the back end, which is the governance part. It's the governance, the maintenance, the testing aspect of the CCPA privacy program after it's launched. So My thoughts are that organizations perhaps may be able to leverage existing privacy governance controls within their organization for the build of back-end CCPA compliance, which would be the governance component, because that is something that's going to go on and on. That's not a one and done. Once CCPA is launched within an organization, there still is the requirement to test it, ensure that it works accurately, and the governance piece, just making sure that it's managed.
What may be some impacts to business that CCPA has engendered?
Well, I believe that privacy departments and functions are being created within organizations today, whereas these departments perhaps were not so prevalent a few years ago. There's been a lot of attention on privacy over the last few years, and particularly now with CCPA, I do believe that organizations are standing up their privacy functions, perhaps realizing that privacy is likely not to go anywhere with the multitude of laws coming out. It's only going to ramp up even more. And then also culturally, I think organizations are evolving to include privacy and cyber awareness initiatives, which allow personnel to understand those areas more clearly and to start including that type of privacy language in their organizations. I get happy when I hear people talking about PII. I mean, it's an acronym that, maybe 10 years ago we didn't hear that often in organizations. So I think that CCPA and privacy in general are definitely evolving within organizations as a new norm for the culture.
Yeah. I mean, I think it's a good thing. It's just the level of responsibility that it comes with the territory. So what are some challenges with CCPA and the privacy compliance projects that I assume are multiple that you must be undertaking at this point?
Yes. My thought on that is resources. I believe resources are a big primary challenge for most organizations. Financial institutions, I think over the last 20 years have become very familiar with compliance departments and their functions, and they've come to understand the resources necessary to operate those areas. But privacy departments, and in general CCPA in particular, may require the same level of resources as financial lending compliance departments, depending on the size, scope, and complexity of the organization. So I would say perhaps one of the primary challenges, my thought, is resources.
So, and that's got to be tough, right? Because now you got to go ask for more money and more resources, and that's always difficult to do, but it's kind of like there's not a lot of choice, right? It has to be done.
Yeah, I think that's probably the largest challenge in any organization, whether it be a financial organization, healthcare, technology, whatever the industry may be, because privacy is prevalent to all those industries. And CCPA particularly now, it's quite a mammoth of a project, and yes, resources are a challenge.
Sure. What are your thoughts on the organizations that may not have adequate budgets, resources, personnel to achieve CCPA compliance?
Well, my thoughts are that it's always a good idea for any company to be able to illustrate and demonstrate their consistent good faith efforts made toward achieving compliance. I think that will take a company a long way.
You can't just put your head in the sand. You have, no matter what size the organization is, you have to start to address it.
Absolutely. And I think Mary could probably add a little bit more to that last thought that I had about making and illustrating good faith efforts.
One of the things that was part of the legislative compromise was that enforcement changed in the CCPA. So instead of this broad private right of action, instead only the Attorney General of the state of California can enforce the regulation. Now, they were promised additional resources in order to bring these enforcement actions, but the Attorney General's office has come out publicly and said that they anticipate that they will only be able to bring 3 enforcement actions per year under the CCPA. So that means that companies absolutely need to be thinking right now about complying. They need to be doing their data mapping, and they need to keep records about how they are complying, because I think that if a business is able to show a good faith effort that they are attempting to comply with the CCPA, that most likely they will not be one of the three cases, at least in the early years of CCPA enforcement, that are used to show as an example.
Yeah, and that's difficult too, because you've got, then there's always the interpretation of the law at the judge level, right? That's not necessarily where you always want to be.
Right, and I mean, companies certainly need to be thinking about complying now. January isn't that far away, but also the Attorney General won't begin enforcement until either 6 months after their final rules have been issued, or 6 months after the CCPA goes into effect. Even the preliminary rules have not been issued yet. We expect those to come out soon. But that also means that enforcement of this measure most likely won't happen until next summer.
Sure.
And I will just throw in there one little wrinkle on the litigation front. So even though it's only supposed to be a private right of action for unauthorized access or exfiltration of data that's caused by a lack of reasonable security, in practical reality, we've heard from consumer groups, also plaintiffs bar, California Consumer Attorneys, ACLU, that their view is that they can seek CCPA type relief by just relying on the California's written constitutional right to privacy, as well as the unfair competition law. That was sort of anti the spirit of some of the amendments that were made in Senate Bill 1121, which is the current version of the law. That being said, we've already seen some complaints where literally language from the CCPA is lifted in its entirety and stuck in as predicate acts for unfair competition law cases and com law cases already. So I just want to give everyone a heads up that there's two things. One, plaintiffs groups are looking at using other laws to get CCPA-like relief, but they just won't call it CCPA. They'll call it a deceptive practice under UCL, or a violation of the written constitutional right to privacy. Right. Or similarly, if there is a data breach or the unauthorized access, like even if someone in your organization might have access to data that goes, I guess, antithetical to your access controls, that you could see potentially cases being brought as early as January 2020, because there's no moratorium on the private right of action being pursued after January 1st, 2020.
And this is just California.
Yeah.
And there are how many other states that are talking about this right now? They're probably all talking about it, but there's
14 or so, I think. You've got Maryland, New York.
Well, New York has a pretty expansive version of, I wouldn't even call it a version of the CCPA. It's really a unique law. But I have no idea politically the odds of it passing or not. It combines the idea of information fiduciary, so that if a business collects personal information, they'll have a fiduciary responsibility to protect it, which really would shift the conversation around data security and privacy.
Right. And
it also has a private right of action.
Yeah, and the SHIELD Act did pass, if you're talking about that one, Mary. So that's now law.
But that's separate. That's a separate act.
Yeah. And now when we were on stage with David Lincecum from the FTC, which we'll actually be posting that up on our company LinkedIn page, the video to that. It was very interesting because one of the things David said was that the security is a whole other angle. We're only talking about tracking data.
Yeah.
But when you're talking about the security of the data, and when you look at the New York Act, which is much tougher than anything we've seen so far, and if they make that a federal rule, that really brings something into play that I'm interested in your opinion on, Dominique, which is, when we launched MasterQueue in 2011, in April, right immediately after that, they launched the CFPB. And in April of 2012, basically the CFPB came out and said that, the Consumer Financial Protection Bureau advised lenders that they have a line of sight responsibility for their third-party service vendors. And so I guess one question would be is, do the financial institutions have that same line of sight responsibility for their third-party service providers who are also gathering data on their customers in a similar manner that were guided, when the CFPB issued that bulletin basically saying banks and non-banks must responsibly manage their service provider relationships?
Well, yeah, I mean, I think under the CCPA, what you see is like for things like the deletion right. So I kind of think of these as, the 3 rights to know that Mary pointed to, and then you've got the deletion right. And there, the business has an obligation to share with their service provider any requests for deletion that the service provider, for data that the service provider might be holding on behalf of the financial institution. And as we talked about, there are a bunch of situations where the financial institution will just be not covered by the GLBA exemption and will be just a business under the CCPA. And then there's some affirmative obligations. Also, with respect to just clarifying what data is shared or disclosed for a business purpose with any third party sold to a third party, those are all things that will now need to be transparent under the statute. Just in general, in terms of wanting to, thinking about 1798.150, which is the private right of action, and that being the vector for liability, it seems there that ensuring that the vendors have reasonable security is a good practice, not just for your data security standard like NIST or ISO, but also to minimize risk for litigation. I will say that in California, our prior Attorney General, Attorney General Harris had issued a report that equated reasonable security with the Center for Internet Studies critical security controls. And we've heard Attorney General Becerra speak that he really believes in a lot of the approaches that a former Attorney General Harris took. And so I think, for companies to start looking at their data security, CIS controls overlap substantially with NIST and ISO, but it's probably a good thing for your InfoSec teams to start thinking about to what degree they're following the CIS CSCs.
So what I'm hearing then is that not only is the need to have for larger institution, a very specific data privacy department, and that almost gets carved out maybe separately from your normal regulatory compliance department because it's such a big undertaking, as Lisa stated, with the resources required to do that and everything. But the other caveat is now you have these new security laws coming in that could open up a right of private action if you're not, as a lender, and you're dealing with all these banks or you're dealing with all these third-party service providers. You now have to get in and really audit their systems. Any system that contains the consumer data is potentially a risk. So you have to really ramp up your auditing procedures and policies and the need to know that the data is being secure and shared, and you have that insight into what's happening everywhere.
And an audit, or at least, a certificate of compliance if they're going through ISO,
SOC 2
something, or SOC 2 or SOC 1 type 2. I mean, something that you can be able to continue to track. And that's just a matter, it's not mandated by the CCPA, but it's a matter of good practice to protect against litigation risk. And then under 1798.150, and more broadly, just with the EU and all these other global laws, it's just a really good practice to make sure that your vendors are treating privacy and data security the same way that your company is.
Yeah, and I think in terms of the impact, the impact on each of you, Lisa, obviously it's a significant impact on you, I would presume, correct? This entire CCPA and what else is potentially coming.
Well, I think it's an impact on every organization right now. I mean, just for every company, this is at the forefront.
And Mary, law degree, CIA, analyst, House Financial Oversight, CCPA, what's next for you?
That's a great question. I started MSR Strategies, I think, so that I can help businesses navigate. Because look, we want businesses to comply with the CCPA. It's a win for business. It's a win for consumers. And so I think that where I can have the most impact now is by providing that clarity and insight.
Good. And then Dominique, what's the impact that CCPA has had on your firm at Perkins Coie, and talk about that a little bit.
Yeah, just as GDPR had previously, and just as we're seeing like the rules in the data protection laws in the APAC region, Canada, Brazil, globally, and now California, which I think is the broadest and most seminal US-based law. Our job is to, just as Mary described, help clients navigate this towards, ideally top-line compliance. That's what I call it. We have a video on that topic, but it's the idea of looking at all the jurisdictions that you're in and looking at the data that you have, and then mapping a program that can be operationalized globally for your operations. Clients don't want, 25 different privacy policies. They really want to have one, basically one philosophy as it relates to privacy and data security, and implement that globally. So our job is to really sort of be in the background and trying to see, well, you might be mapping for, your emails to Canada's Castle Law, and then for cookie disclosures to the EU, and then for transparency with respect to what data is sold to California. But the key is for us to just be like here, using those 6 steps and helping clients tweak where they need to in their gap assessment, but essentially have a program that will be able to stand the test of time.
Yeah, sure. I think that really makes a lot of sense. And I think, what's interesting about our relationship that we've built with Mary and with you and your firm is, we've got our lenders coming to us and saying, okay, we need to address this. How do we do that? You're one little piece of what we do in debt collections and data gathering. How can you help us do that? And we're as, to begin with, we're as confused as anybody was, I think. But now we have a lot more clarity. And I'm a skip tracer, so that's why I'm sitting here talking to you and why I'm talking to Mary, because I wanted to go to the people who really knew the most. And you're going to be at the IAPP as the keynote speaker the same day we're at Finovate in New York. But talk to me about the IAPP and why you think companies should join that, and coming to that privacy conference as well.
Yeah, so and Mary has spoken, on many times on our CCPA panels for the International Association of Privacy Professionals. I think it's really a great resource and a great way to see what's going on and what's coming up next. I'm excited to hear about from you, actually, John, about MasterQueue, because I know MasterQueue is nominated, and you're now a finalist for 2 awards at Finovate in New York. You just mentioned you'll be there. Mm-hmm. And one is for a reg tech solution that you built in partnership with a very large financial institution that we will keep confidential. And the second is for the collaboration and partnership with the financial institution that you innovated. So can you share some details around Finovate and
Sure.
what you're doing in MasterQueue?
Yeah, we that's where we launched our platform, just because a lot of the banks, they have these old legacy systems that don't have the nimbleness and the ability to operate like a fintech. And so this is a showcase of the top 75 new products or fintech platforms that are out there. They look at hundreds and hundreds of fintech companies. They pick 75 to present, and it's literally 7 minutes on stage, live demo, and then the next guy goes. It's very fast paced. It's very exciting. You've got 1,500 banks and investors and such in the audience that are all tweeting out whether you're good or bad. So it's no pressure, right? But it's a lot of fun, very exciting. If you've never been to the show, it's great. And it's really a lot of fun. And we were, accepted as a presenter and then nominated for these awards. And basically we went in and we had a lender come to us and say, hey, well, there's all these different states and all these different laws. We're bringing all the data in through MasterQueue. How can we attach these rules so that not only can we internally be able to track who we're calling, when we're calling them, who are we not supposed to call, but how can we pass those rules on to our vendors? If our vendors are using MasterQueue, then we don't have to audit multiple other systems the vendors are using. We're going to audit MasterQueue. The vendor uses MasterQueue. And then when they gather data, maybe similar to what we gathered, those rules are attached to it. So we'll be presenting that, and we're really excited about starting the discussion around what we're building for data privacy, because that's the next thing that has to be out, January 1st. We have the ability to go in and see what data you have because we're tracking it all in trackable fields. Mm-hmm. But I don't have the whole piece built yet because I haven't had enough feedback back from people like you and Mary, mm-hmm. People like Lisa, people who are clients of ours, to be able to say, what is it that you guys want? And then from the vendors as well too, and how does everybody work in one common system for this very tricky, job of tracking all the data. So we're, I don't know, we're up against Western Union and big, huge companies, and we're a small little company, so it's really exciting for us. But hopefully some of the people that are on the call can come see you and maybe come see us as well. What day are you speaking?
I'm speaking, the keynote is on the 25th, but on the 23rd, I'm on the faculty for IAPP's Understanding the CCPA day-long seminar. And then on the 24th, I'm speaking on a workshop for privacy programs, just how to build a privacy program. And then the 25th in the morning, I think it's at 9:30, is the keynote with Stacy Schesser from the AG's office, Alistair McTaggart, who co-authored the CCPA initiative along with Mary, and then Travis LeBlanc, who used to be with the FCC, but now he's a partner at Cooley.
Fantastic. And that's, what city is that in?
Oh, I'm sorry, Las Vegas, and it's the International Association of Privacy Professionals, IAPP, Privacy Security Risk Conference.
Yeah, so you could come see Finovate on the 23rd. We present on the 24th, 11:30. Take a red eye to Vegas and be there for your presentation the next day, and really just get more data privacy than you want, right?
Well, why not?
Right. All right. Well, one last quick little question that I had come in here is, January 1st, the law goes into effect.
Yes.
Can a consumer, is that where the clock starts ticking, as far as if the consumer makes a request and says, what data do you have on me? Can they say, what data do you have in 2019, or is it only going forward 2020?
My understanding is that they can make the request going back a year. So what companies are doing right now to inventory their data and know what data they have is very important, because that could be the subject of a right to know request.
Gotcha. Okay, great. All right. Well, I just wanted to say, first of all, thank you so much, Dominique, Mary, Lisa. It was a pleasure. And hopefully everybody gained a little bit of insight in regards to this. And I'm sure we'll have a follow-up here before the first of the year. And thanks again to everybody for joining.
Thank you, John.
Thank you.
Thanks, John. It was a pleasure.
Thank you.
For those of you participating in this webinar, the CLE code for this session is privacy. Please be sure to record this in the appropriate box on the remote attendance affirmation form that was provided.